has paid for a general list the matter after
4 weeks. Interim order may be continued.
interim order shall remain in force till the next date of discriminating.
Okay.
Review.
May it please your lordship. Lordship, we're back to mention item number 16.
Mm.
Lordship, we had filed an additional affidavit, lordship, that may be called.
Okay.
Lordship.
Item number 1 was on.
Please, your lordship.
Yes.
No, this is the second time bail application. What I'm praying before your lordship, my lord, since some developments have taken place, lordship will kindly call for the up-to-date case diary, my lord. This is my humble prayer before your lordship. Some developments have taken place
case diary.
during investigation. Only up-to-date case diary may be called. Yes, sir.
Call for the up-to-date case diary, list the matter. When do you want?
My lord, in the last week of November, my lord, if possible. This is from Nagaon.
27 November.
My deeply.
Item number 2 or at least.
Since a revision before against an order passed in an appeal where
We'll have to hear the other side also for admission.
Well, may I point out another thing, Malab?
Hmm.
If your lordship kindly peruse this order dated 30th of November 2018.
2018.
2018. Actually, this brief was not originally mine. This has come to me. An IA, records of an IA was called for. Lordship will see. And thereafter, there is an office.
I was not called. In view of the revision petition is ready as regards service and be now posted for admission.
Then your lordship
Along
kindly.
IA stated to have been
Yes.
filed under serial number in connection, yes,
Yes.
was called.
So, well, there is an office note saying that the IA could not be traced. Well, though this brief was not originally mine, I have checked the e-codes, my lord. I have taken a print out, my lord. Your lordship will see the IA is still lying with the filing number, my lord. Same filing number.
We'll call for the IA then.
Yes, your lordship may kindly call for the IA. Well, it's a petition for injunction, my lord. Order 39, Rule 1 and 2.
All right. Learned Counsel Mr.
B. Goswami.
is present for the petitioner and has submitted that the order dated 30/11/2018 clearly reflects that IA stated to have been filed under serial number 13567/2018 was called for, but the IA has not been forwarded. What is this?
Well, that is a screenshot of from the e-codes, my lord. The office note says that the IA could not be traced.
It is submitted that the status of the e-codes that the screenshot submitted by the learned counsel for the petitioner relating to the status of the, it is submitted to the screenshot of relating to the status of the e-codes clearly reflects that
IA was filed.
Clearly reflects the filing number, filing number of the IA.
In the e-codes, my lord, the status is still shown pending.
Contrary to the office note dated 1/7/2023, that IA could not be traced out, as the screenshot also reflects that the IA is still pending.
Yes, still pending.
Ready to place the IA as per the screenshot. We still place this screenshot will form a part of this record. We ready to place the IA on record. The respondent is not represented today. List this matter positively for admission on after 2 weeks. Positively for admission after 2 weeks.
Briefly on that.
Item 3.
There's a lot of the English council is stuck in traffic, so matter may pass over the time being.
Let it come in the next month, madam.
Next month. Learned counsel for the petitioner has submitted that the, Mr. What is the name?
Shisham,
C. Sharma has submitted that the engaged counsel, learned counsel, Mr. C. Sharma has submitted that the engaged counsel for the petitioner is in
Stuck.
another court.
no,
Stuck in
Lordship, stuck
traffic.
in traffic, Lordship.
Huh?
Stuck in traffic, Lordship.
So, has not reached the court and he's stuck in traffic jam. To stop, learned counsel, Mr.
A Iqbal,
A. Iqbal is present for the respondent, list this matter after 4 weeks
17, madam, next Monday.
Next Monday.
or 17.
Seven.
List this matter on 17/11.
Obliged.
Obviously.
Item number 4.
May I please your lordship?
Yes,
Mr. Lana Senior Counsel, Mr. L. Datta is not present today. So kindly adjourn the matter.
petitioner is not represented.
Kindly list the matter on Friday.
To stop, learned senior counsel, Mr. S. Doctor is not present today. Learned counsel, Mr. Miss
As per.
S. Pal on behalf of learned counsel, learned senior counsel, Mr. S. Doctor has prayed for adjournment. List this matter on Friday. Item 5.
Made visible. Lordship, this is a matter wherein we have challenged the my petition in the title suit matter. My petition for impleadment was rejected, madam. However, my lord, the notices were issued and were order dated 10/5/23 it was deemed to be served on the respondent. However, they have not appeared.
Order dated 10.
5/23.
You can place your submission for admission.
What had happened, my lord? The respondent as plaintiff had filed a suit for specific performance for delivery of a flat. Now, the suit was filed against one Nita Jain, my lord. Now, the Nita Jain is the second wife of the husband of the petitioner. So what had happened, the petitioner herein is the first wife who stays at Jaipur. Now, the husband of the petitioner during his lifetime procured a flat jointly with one Nita Jain, who is the defendant in the title suit. Now, after the death, my husband's death, that is Annexure 8, my lord, at page 43, I came to know about this flat, my lord, and regarding the suit, which is pending in Civil Judge number 3, Senior Division, Kamrup Metro. Now, after I came to know, as my husband was the co-owner of the flat, I filed one impleadment petition in the suit to implead me as a defendant. Now, that was rejected, madam. Simply on the ground that I do not have any right because the plaintiff does not have any privity of contract with me, being the first wife. As such, my this petition was rejected, madam. The operative portion is at page 71, madam.
Page 71.
71, madam, at the last paragraph. In the case at hand, on a meaningful reading of the plain, it transpires the suit filed by the plaintiff is essentially for enforcement of the oral agreement between the plaintiff and the defendant in respect to the suit property. whether or not the petitioner is a necessary party to the suit would depend upon the question whether the presence of the petitioner is necessary for complete and effectual adjudication of all the points of controversy arising in the suit. Admittedly, the petitioner is not a party to the oral contract between the original plaintiff and the original defendant. In the event of imprisonment of the petitioner as a defendant in the suit, the character of the suit would change altogether. It is not legally permissible for this court to go into the question whether the petitioner has acquired any interest over the suit property on the basis of a claim that she is the wife of the original co-purchaser of the suit property. Now the order itself reflects that my husband was the co-owner. Now after his death, by way of inheritance, my right as well as my son's right becomes determinable over the suit property. As such, I may be imprisoned and given a chance, my lord, to place my case because I am a necessary party because now I have a right in that flat. Pure. Now, next of kin certificate is also there, whereby page 41, whereby my
We'll admit it. We'll admit it, we'll call for the records, scan copies. No stay will be granted.
stay is already there.
Oh,
Operative.
stay is already there.
Operative till disposal.
Huh?
It
Till
stays
disposal.
operative till
Okay.
disposal.
All right. Then we'll call for the scan copies. Otherwise it will take some time. Learned Counsel, Mr. K.R. Borua
Yes, ma'am.
is present on behalf of the petitioner. And has submitted that the petitioner is aggrieved by the order dated
8/12/22. Page 70.
8/12/22 passed by the learned civil judge number 3, Kamrup Metro, Guwahati. Full stop. It is submitted that after the death of the petitioner's husband, he along with her son are the legal heirs of the what was his name?
My lord, is
Sethi, no?
not my lord. Mahendra Kumar Jain.
Mahendra Kumar Jain. First of, the dispute is regarding to a flat. And the respondent, who is the second wife of late Mahendra Kumar Jain, has staked her claim over the she's claiming right over the flat,
Yes, ma'am.
over the flat. Full stop. The petitioner is aggrieved as the learned trial court has observed herein, observed that the petitioner is not a party to the oral contract between the original plaintiff and the original defendant. Full stop. In the event of imprisonment of the petitioner as a defendant in the suit, the character of the suit would change. Full stop. It is further submitted that the original title suit being PS number 178 of 2021 was between the petitioner and the petitioner's
Between the my lord respondent and one Nita Jain.
between the respondent and another person, namely Nita Jain. Full stop. Between the respondent, no?
Between the respondent.
Respondent लिखिला ना? Present respondent लिखिला. I have considered the submission that the petitioner and her son is the legal heir of late
Mahendra Kumar.
Mahendra Kumar Jain. But the course of the proceedings have already been stayed by this matter is listed for admission. The respondent is not represented, despite the fact that notices are deemed to be served on the respondent. Call for the scanned copies of the trial court. list this matter for hearing and it will be for orders now. We will go back to orders now. List this matter on after 1 week. Did you scan copy here? 2 weeks did you? 2 weeks. Scan copy did you?
Yeah, President.
Hmm.
So this is a petition against the interim order passed by the civil judge Borpata. And the case is that we filed a money suit. And in due time, we could not take steps and the suit was dismissed for default. There we filed a petition for restitution with the continuation delay for 50 days. For the trial court bill on going to the petition dismissed. So against the petition, we filed this revision petition. And other side, they had turned up and they filed their affidavit. And their only issue is that the firm was dissolved. Lordship. Firm was only their issue. So may I simply pay another matter?
We'll have to tell the other
Yes,
side
Lordship. Yeah,
for admission and
Yes,
other
no.
side is appearing, I think.
Yes, only last token is also absent, Lordship. If I'm not mistaken.
Yes,
Yes, that matter we fix other than issue.
other way.
Yes, yes. Issue is
If
some.
we don't turn up, then we'll pass.
Yes, yes, the
we'll
issue
pass
is very
order.
simple because no, case should be go for trial only, very initial stage only, the case was dismissed.
But we'll have to.
Yes, Lordship, because they are
Come
affidavit.
what may will happen.
Yes,
with the
yes,
other
Lordship.
side. Learned Counsel, Mr. BJ Ghosh.
No, Lordship, delete.
Mr. Dilip Dey is present for the petitioner. The respondents are not represented today. List this matter on, when do you want?
After 3 weeks.
After 2 weeks.
Yes.
List this matter after 2 weeks on absence of any of the parties. On the next date fixed, necessary orders may follow.
Okay, date may be fixed, Lordship.
Date, the reduction 2 weeks, sir. 25th November.
Lordship, can it be, it's 26, 25th, that's the problem.
When?
26th.
Your Lordship, the council seeks some more time. So the case may be adjourned.
I didn't know represented.
Yes, yes, Your Lordship.
Petitioner is not represented today. Learned Counsel, Mr.
A Mishra on behalf of S Das.
A. Mishra is present on behalf of Learned Counsel, Mr. S. Das. List this when you want.
After 2 weeks. Lordship.
List this matter after 2 weeks.
Much obliged.
Wait.
Sir. দুইটা পার্টি কেলে আহা নাই গম পোৱা নাই নেকি?
Wait, please, sir. No, earlier occasion, my lord, the other,
They didn't turn up.
no, petitioner councillor withdraw their name from the Wakalatnama.
Okay.
And this honorable court, my lord, directed to issue notice to the my lord, petitioner, my lord. Perhaps, my lord, service is completed, my lord. Kindly see the order dated, my lord. Office note dated, my lord.
For the petitioner, okay. Making several tries, she could not communicate with answers, she may be permitted to withdraw her name. The praise allowed, the registry shall issue notice to you.
The office note, my lord, 02, my lord, 07, my lord.
0207. For alternative arrangements for representation. That's right. Notices have been served. We'll wait for 1 day.
My lord,
1 day, only 1 day. It's not good dismissing. Because you see, this case will get stuck again.
my lord.
Office note dated 2/7/2025 reflects that notices have been served to the petitioners. Most of the petitioners are not represented today. Learned Counsel, Mr.
HP Gwala.
H.P. Gwala is present for the respondents. List this matter positively for admission on the next date. For the positively for admission, full stop. On absence of any of the parties on the next date fixed, necessary orders may follow. You want a
Obliged.
date, no?
My lord. Obligement.
Metra will pass for the timing option.
10.
That's-
I am appearing for the respondent, my lord. This is a contempt petition. My lord, we have filed our affidavit. showing that there has been no contempt as such, my lord, in this case.
So they are absent.
That is why, my lord.
But
And
we-
moreover, my,
We'll hear you. We'll hear both sides. One last date.
yes, your lordship. Because what has happened, my lord, the order against this disobedience has been alleged, my lord, that has been reviewed.
Okay.
We filed a review application that has been partially allowed of this.
There's no contempt.
No, there cannot be any contempt.
They will agree to it, then we will close this case.
Lordship,
They're not present today.
lordship.
Learned, or the petitioner is not represented. Petitioner is over. The petitioner is not represented today. Learned counsel, Mr.
Ji Rahul, my lord,
G. Rahul is present for the respondent.
respondent.
List this matter on
26th of November.
earlier date. You want an earlier date?
Lordship.
26th November or an earlier date?
Nalage, nalage. 26th
November.
is it?
26th. Mm,
This is a matter of application, where one of petitioner was responder,
mm.
question number 33. I'm not found totally on merit, lordship. Only my lord, but my lord, the immediate lordship. That case is not completed to the standard session potential. Still my lord, NCL lordship. Therefore, it did not appear, my lord. If we appear, my lord, then my lord, we put the rest. So my lord, case number 33.
I'll go to the merits. I'll go to the merits.
Lordship.
I'll have to consider the bail petition. You are not concerned with the merits, but I will go to the merits.
Lordship. In fact, my lord, similar case, my lord, video two is there, lordship. Therefore, lordship, in another, my lord, coordinate bench, my lord, case number 38. That's granted bill, lordship. Rather, submit this, lordship. In similar case, video two is there. My lord, coordinate bench held and my lord, trial with delay, lordship.
Very speaker to on call, yes, speaker to just try put on the speaker. Yes. Yes, speak loudly. I cannot hear what you're submitting.
Lordship. Lordship, we find it page number 33, with the matter search. Where my lord, the petitioner is shown as responder. Therefore, my lord, someone issue lordship could not appear due to my lord, case is not committed to the learned session. My lord, section is trial by learned session, by the court of session. My lord, in a similar case, lordship, case number 38. Relevant paragraph, my lord, kindly come, my lord, 41. Lord. There was a finding, quite content window. In spite of my lord, gravity of the offense, my lord, kindly come to the place of 41. Take this, madam. Lord.
Yes.
Lordship has got it. Paragraph 8, Lordship. Considering the gravity of the alleged offense, the significant increase in materials against the petitioner, and the primary facie consequence of their alleged criminal act resulting in death of one person and injury to several others, perhaps unmade, it might not be a fit case to grant anticipatory bail. My lord, paragraph 9, my lord. The petitioner have been indicated as absconder, my lord, similar to the my lord present in the search, lordship. The case is stated to be at the stage of appearance and pending for committal. In my considered opinion, not much purpose may be served by keeping accused person in detention, lordship. Provided their presence can be ensured, stringent condition imposed to ensure that they do not harm any member of the informant side, refusing bail to the petitioner at this stage might even delay commencement of the trial. Therefore, despite of great nature of the material, reveals looking at the matter for the point of view indicated above, I am inclined to grant anticipatory bail to the petitioner subject to.
All right.
I prefer my lord. They are ready to my lord face the trial, lordship. Lordship makes Otherwise, my trial is my lord delayed.
It is now before my lord committal court, my lord. They have my lord issued my lord NBW because
Case is already in the committal court.
yes, my lord. My lord.
Still, my lord.
SDGM.
Yes, sir.
This is the
SDGM,
committal court.
Committal court, my lord. Yes. So my lord, before that, my lord, and my lord, they issued my lord summons, my lord, as they didn't appear, my lord. So my lord, NBWA is issued for many dates, my lord, but that was not executed. Other than that, my lord, is a matter of my lord, that is FIR dated 10/11/2017, my lord. Date of incident is 9/11/2017 at about 2 p.m., my lord. And CS was filed on my lord 25/2/2022, my lord. And my lord, this first summon is issued on my lord 4/4/2023, my lord. Now, my lord, next date is fixed in the month of December, my lord. My lord, that is NBWA issued.
One accused.
My lord, against the both the accused, my lord.
There is three accused, my lord. One accused arrested, lord. He faced the trial, lord.
One is arrested, my lord. My lord,
Wait.
I have flag marked the last order also in the, my lord, that is the order sheet. And also, my lord, 164 statement of both the vital witnesses. One is the mother-in-law, who at that point of time present with the victim, my lord. From her, my lord, that is the big, that is the money bag, and the other was snatched by the petitioner number 2, my lord. That is the accused number 2, my lord, Sufal Patikon.
Oh, we have two petitioners here.
Two petitioners here, my lord. Petitioner number 1 is my lord, sir, accused number 2 in the my lord FIR, and my lord petitioner number 2 is the accused number 3 of the FIR, my lord. One is already arrested, my lord. They are there, my lord. So that is the case, my lord.
On merit, my lord, the allegation not against the petitioner, my lord. They are just finishing the stain and parts of it.
My lord,
Main accused
those
Kolabati-
parts are there, my lord, against the accused number, my lord, accused 2, that is the petitioner number 2, my lord. That's my lord, direct implications is there. Two numbers of my lord 164 statements are there, my lord. One is the independent witness, another was the person. She is also victim, my lord, mother-in-law, who is present in the. was
Where
present.
is the FIR?
FIR, my lord, page number 22, lord. Vernacular.
Earlier, bill was not rejected.
Other than
Please-
that,
please
my lord,
read
it's
the
a my lord 17 matter. 2007.
Due to my lord, non-appearance of the present petitioner, my lord, the trial
Please
is.
read the FIR.
Yes, sir. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ ভাতৃ বিদ্যুৎ শইকীয়া তেওঁৰ শাহু মাকৰ লগত যোৱাকালি দিনৰ 2 বজাত উত্তৰ লখিমপুৰ নগৰৰ পৰা ঘৰ অভিমুখে গৈ থকা অৱস্থাত ওপৰৰ পক্ষগণৰ তেওঁলোকৰ পদূলিমুখত আগৰে পৰা হাতত চোকা অস্ত্ৰ লৈ খাপ পিটি থাকি মোৰ ভাতৃক পিছফালৰ পৰা ওপৰ পক্ষগণৰ MN দুইজনে মূৰ আৰু হাতত ঘপিয়াই গুৰুত্ব জখম কৰে। ওপৰ পক্ষগণত 3 নম্বৰ জনে তেওঁৰ শাহু মাকৰ হাতত থকা টকা আৰু যাৱতীয় নথিপত্ৰ বেগটো আজুৰি লৈ যায়। 3 নম্বৰ পিটিশ্যনৰ আছে। মোৰ ভাতৃক উত্তৰ লখিমপুৰ অসামৰিক চিকিৎসালয় চিকিৎসা কৰি থকা অৱস্থাত আজি পুৱা 3 বজাত মৃত্যু হয়। গতিকে দয়ালু মহোদয় দয়া কৰি দোষীক আইন মতে উচিত দণ্ড দিবৰ বাবে প্ৰাৰ্থনা জনাব। My lord, allegation against the 3 number question also, my lord.
Accused number 3 is Kukhal Konikor, my lord, who is the petitioner number 2.
Here. If we go, my lord, by merit lordship, then my lord, there is no implication in that, lordship. For the petition number 2, lordship.
Kaya ko committal court আছে, এখানে promote করবো। Trial court নাই যে।
No, no. You appear before the court.
My lord, I will It's in my lord behind the bar. In my lord.
You appear before the court. Heard learned counsel Mr. D. Gogoi for the petitioners.
Also, at least protection may be
We
given.
have eyewitnesses. No. Petitioners Mona Khonikur alias Kehol Khonikur for the.
Map A4 then that.
No, no, no. no. I have tried to explain you in this way or that way, and you wouldn't understand what I was trying to explain. So many times I have given adjournment, not today.
No, my lord, this is not. that.
No, no. File an application under section 482 of the BNWS 2023 with prayer for periods bail as they are apprehending arrest in connection with so and so. So and so PS case under so and so sections, heard Mr. G. Bush, learned edition PP Assam. The allegation against the petitioners is there. Or
To discuss my lord, because earlier.
please, I'm dictating the order, please, don't disturb. Allegation against the petitioners is that on 10/11/2017, the petitioners were waiting in ambush,
Yeah, what is your problem?
and at that time, the Vidyut Sukia was proceeding along with his mother-in-law when the petitioners attacked.
One second, bail application.
Vidyut Sukia.
My lord, may I submit, my lord, one thing? Learned friend stated that this is a second bail application, my lord. And my lord, that is a one affidavit is filed, my lord, in this regard, my lord. In the earlier petition, my lord, that is not, my lord, annexed, my lord. So it is a second bail application, my lord, they stated, my lord. But right now, I don't have that is the affidavit.
Yes, yes, yes. Record is there.
So what to do with the affidavit?
My-
I'll go through the affidavit.
No, sir.
I have the affidavit.
Yes.
I'll go through the affidavit, but I'm not granting bail. The affidavit is here now with me.
Asan
In
nahi.
this record.
In the record.
Then it is okay. If-
I'll go to the affidavit.
Yes.
When the petitioners attacked Vidyut Sukia, full stop, the accused, the petitioner number 2 snatched away the bag from Vidyut Sukia's mother-in-law, whereas the accused number 1 named in the FIR and the petitioner number 1 attacked Vidyut Sukia with the dowel. With their dowels within bracket machetes, bracket close, which resulted in the death of Vidyut Sukia, full stop. It is submitted on behalf of the petitioners that the petitioners are not responsible for the death of Vidyut Sukia, full stop. The accused number 1, who is responsible for Vidyut Sukia's death, has already been arrested and forwarded to custody in connection with this case. I don't have the affidavit here.
You will also file.
Oh, yes.
Let me just annex the order. Absolutely.
Why didn't you tell me before, but Now I cannot recall the order. This is the second bail application. Why didn't you tell me before? Now I cannot recall the order. I have already made up my mind now.
So we fix some other day election.
No. See, what is this?
As what I was next.
You are not prepared also properly.
On merit.
Midway when I'm
no,
rejecting
once-
judgment, you are submitting about the second bail application.
I'm not on the go to the merit of the case. Technical ground of
What technical ground?
164, my lord,
Technical-
clearly.
The main technical ground you didn't mention before me.
Yes, ma'am.
The second bail application.
Second bill, we could not find my lord, thereafter we filed it. Immediately thereafter we have filed it available also. It's not my lord suppress also. So on Friday also, if possible also,
No.
I have to go to the merit also.
My lord, clear implication, my lord, 164 statement. I have already flag marked, my lord. Not only, my lord, that, my lord, the mother-in-law, apart from the mother-in-law, my lord, independent witnesses also there, my lord.
That I have.
Who clearly stated, my lord. Who clearly stated, my lord. And the person died, my lord, immediately after that. And then on, my lord, the next day, my lord, FIR was lodged by the brother, my lord.
You ought to have apprised me about this application, then I would have passed an order differently. So now I have already dictated the order and midway, halfway, how can I change the order? Initially, I was under the impression that this is the first bail application before this court. So that is the main important point on which I was proceeding to dispose of this case.
So in the, while filing the present bail.
No, now I cannot, you see, how many adjournments I have granted you earlier?
No, my lord, in this case, no adjournment, my lord.
No, I have
It
granted
defines-
several adjournments.
My lord, that is the other case also. That is the other case. Which speaks on, my lord, on Wednesday also. That is the defined case. Wednesday, lordship speaks for further hearing, because there is a Supreme Court case pending also.
Okay.
That is the defined case also. This is the my lord case also. Okay.
All right, then I can grant you adjournment.
Lordship, grant me a time to.
I thought
can-
this is the same case.
No, lordship. Therefore, I submitted also.
All right.
Lordship.
Learned Counsel Mr. D. Gogoi has prayed for adjournment, list this matter on date 17 November. All right.
Lodged. Deeply obliged. Obliged.
Admission.
Lordship, we want to file an affidavit, although it is prepared but not signed
Yes.
it.
Petitioner is not represented. Appellant or petitioner. Come on, hey, did you already? Last date also petitioner was not represented.
Yes.
I won't dismiss it because I think they will
No,
come
no,
again
that's it.
and then
Yes,
pray for.
It has to be adjudicated.
Start again.
Yeah.
Petitioner is not represented today. Learned Counsel, Mr.
You do.
You doctor is present. So your submission may not be recorded because
No.
they have not appeared.
Yes.
You filed the affidavit.
Yes.
This matter after 2 weeks.
Item 30 or orders.
Yes, enough, enough.
Please, Lord.
Your Lordship, in this matter, we have filed an appeal for enhancement in the awarded amount given by this member. We have taken step against OP 1, 2, 3, and only one appeal.
Learned Counsel, Mr. Yonu,
Irangogar,
Wrong,
Irangogar, for AG Chaudhary.
Nampi Gulgo, huh? For, on behalf of Learned Counsel, Mr. A.D. Chaudhary is present. Learned Counsel, Miss.
A Biani,
A. Biani is
on
present
behalf
for-
of, for respondent number 1, Your Lordship.
is present on behalf of respondent number 1. Service report on respondent number 2 and 3 is awaited. List the matter after 2 weeks. 3 weeks, 4 weeks.
Kindly allow us to take first step.
Okay. 4 weeks.
Yep.
Petitioners may take fresh steps to issue, appellants, petitioner will be very participant. Appellants may take fresh steps to issue notice to the respondent number 2 and 3.
Much of
Reasonable within 4 weeks. List accordingly. Item number 14 and 15.
May I please, your Lordship? Lordship, item number 10. I'm for the petitioner, Lordship. After 2 weeks. Lordship,
Already passed an order.
Lordship, and the date may be fixed because
No. Because the other side has the other side was present and I have already dictated and it was fixed after 2 weeks. After 2 weeks only. Oh, there.
Yes.
Okay. Yeah, and date can be fixed. Okay.
last time it was.
Date can be fixed. Yes. You give me the date. When do you want?
That may be the date.
Lordship. November. Yeah, November last of the.
November, last December, November.
Lordship, this November, any date from 24th of November.
It will very patient not within the Jagat. Your name?
A. Mohammed.
Land Council Mr. A. Mohammed is present for date. Petitioner.
Lovely.
Obla.
Already received. Lordship. 14 and 15.
Readings are complete.
How many instructions?
Yes, we have the LCR. Readings are complete.
Fitting Lordship, the steps are already taken in item number 14, Lordship. The last location, the
14.
Item number 14. Last location, Lordship, the Council R. Shahan has appeared on behalf of the respondent. Lordship. The service has been already complete. Lordship.
I'll just see it. Steps were not taken.
Lordship, there appear Lordship, R. Shahan, that in the last location.
Only one
Only one response.
So we'll file our Wakanatama by next day.
Okay, then it will come back for orders only then. Dipanath. Huh? Dipanath. Learned Council, Mr.
DC Nath.
DC Nath is present for the appellant and Learned Council, Miss.
S. Pal, appearing on behalf of DJ Mukherjee.
Both the cases, you are the appellant.
Lordship. Lordship, both of it is the same appeal.
Okay.
We appeared for item number 15. But 14, we will file our Wakalatama.
The Learned Council, Miss.
S. Pal.
S. Pal. S. Pal is present on behalf of Learned Council, Mr.
BJ Mukherjee.
BJ Mukherjee and just submitted that Wakalatama will be filed for Met Appeal number 48 of 2022. List this matters on after 2 weeks.
Deeply obliged.
Or you want an earlier date?
No,
Because she has to submit
Yes,
three and Wakalatama.
has not submitted the Wakalatama. Both the cases.
2 weeks.
Obliged.
Items 16 and 17.
Wait, please, your Lordship.
16 and 17 together.
Yes. Before your Lordship goes to the record, I'll just say, my lord, in this case,
What is 17?
the state has taken this court for a ride. I'll just explain you how. My lord, there is an order of Jimma by the Sessions Court somewhere in the year 2022. Jimma of certain suparis with a condition that you furnish a bank guarantee and take the suparis because certain suparis were seized. My lord, the petitioner, being aggrieved by the condition of bank guarantee, filed a criminal petition before this court, praying that kindly relax this bank guarantee condition and instead of bank guarantee will execute bond.
Criminal petition for what, sir?
Your Lordship, I'll indicate the page number and everything. I'll just give a brief background how this case has come.
So in 2022 session court granted Jimma of Supari with a condition of bank guarantee. Being aggrieved, the petitioner filed a criminal petition before this court. In the criminal petition, we prayed that kindly relax this condition of bank guarantee. The court was pleased enough to relax this condition and impose a condition of execute a bond and take the Suparis. We write to their SP, we write to their OC that see this is the order of the court. They, I do not know under whose political pressure or I do not know, they did not release the Suparis, my lord. Now, my lord, in the meantime, we filed a contempt petition. Now, during the course of the contempt petition, an affidavit was filed by them. In the affidavit, they say that even we filed a criminal petition against the order of Jimma by the Sessions Court. They were aggrieved of the Jimma. We were aggrieved of the condition of bank guarantee. Now, in that criminal petition, they obtained, they got a stay order. Now, my lord, 2022, they got a stay order. They don't take steps. This stay order remained in the records of the court. It was never communicated to anyone. After 3 years, when this matter came up on August 8, before another bench of this court, I made a submission that, my lord, we do not know about this order. Because now, in order to save themselves from the contempt, they are taking help of that order. Now, they say that since it was stayed by this court, therefore, we did not comply with this order. My lord, when an interim order is passed, it is incumbent on them to take steps. Let us know. Now, after 3 years on 8, the court, when they made that submission, the court says, tag both the matters. The order is there. Say, tag both the matters, we want to verify. Immediately on 8, my lord, after 3 years, they take steps. Your lordship will see the office note. They take steps and they let us know that regarding the stay order. After 3 years of keeping my Suparis in their custody. My lord, is it not, my lord, abuse of the process of law? For 3 years. Now, my lord will see, I'll indicate certain things. Your lordship will kindly take up the contempt petition for a while. The contempt file of the contempt petition is there with your lordship. My lord will see, first, the order passed by the Honorable Session Court granting Jimma. This order is dated, my lord, this order is dated 38/2022.
38/22, which page?
Page number 15 of the contempt petition.
Okay.
My lord has, your lordship may skip all these. Just the operative part, I'll take your lordship to page number 33. Operative part, page 33, para 45. My lord is there.
Yes.
Para 45, your lordship will see. The IO is directed to hand over the seized Areca nuts in Jimma of the petitioner, namely such and such, within 2 weeks on the condition of furnishing bank guarantee, each by the petitioner from any nationalized bank to the like amount of the valuation of the seized property. My lord have seen. This was the direction by the Sessions Court. Bank guarantee. I filed a criminal petition before this court. My lord will kindly turn to page number 36. The criminal petition, page 36. The operative part, what this court has observed, your lordship will find at page number 39, para 7. My lord is there?
Yes.
Upon hearing the learned counsel for both the side and considering that, now, my lord, in all these cases, the states were represented by PPs, additional PPs. These are not ex parte orders, my lord, none, because here after both the sides. Upon hearing the learned counsel for both the sides and considering the grounds cited in the petition along with the documents annexed thereto, it is provided that the petitioner shall furnish indemnity bond. So it was relaxed, not bank guarantee, now indemnity bond. Indemnity bond of equal value as determined by the learned court below in his order passed in criminal act instead of bank guarantees. The petitioner shall, however, mention their bank account number enclosing therewith the initial relevant pages on such bank passport. In lieu thereof, land documents may also be furnished as the. In short, instead of bank guarantee, indemnity bond was there. Now, my lord, while this order was passed by this court, the state was represented by the learned PP. No submission whatsoever was made that there is a parallel case which we have filed where we have obtained a stay order. That ground was never taken up. Now, my lord, we write to their SP, their OC, no reply, no communication, nothing. We are government, we can do anything and everything. Now, my lord, as a citizen, having no other option, he filed this contempt petition. He said willful disobedience, he has filed this contempt petition. Now, in this contempt petition, they filed an affidavit in opposition. Now, in this affidavit in opposition, they take a plea. They take a plea that this order passed by the learned session judge is being stayed by this court in another criminal petition, and that order your lordship will find at order 2. That order your lordship will find
28/4/23 orders, one.
28/4/23. Yes, that order your lordship will find in their affidavit in opposition, page 82. My lord is there at page 83. Page 83, the order dated 38/22. 38/22, which has been stayed, that is the Sessions Court order. Your lordship has seen that? Huh?
Yes.
Now your lordship will see the last order passed by this court in the content petition. That will be there in the office note, my lord. The 8 order your lordship will kindly see. Your lordship has seen 8 order.
8 order?
8 of August 2025. Tag both the this.
Which page?
No, this is not page, my lord. Your lordship will find in the record, main record.
Okay, all right. My order.
Yes.
8 August 2025.
Ha. Judicial order.
Yes.
My lord will see tagging order is passed.
Yes.
We were taken by a surprise, my lord, that how come this order was passed? Because we do not know. So we said, I apprehended on that day itself that probably they did not take steps. They just, once they get a stay order, their purpose is done. Now your lordship will see, on 8 they take steps. Now your lordship will turn the office note.
Okay.
And now your lordship will turn the office note of the criminal petition. That is item number 17.
On 8 August, they took steps?
Yes, of 2025, they took steps.
In this case?
Yes, criminal petition, because they obtain a stay order in this case. So your lordship will kindly see the office note. Whatever I am submitting, my lord, from the records. We'll see the office note of this.
Yes. They have taken steps on 8 August. Yes.
After how many years? 2 years and 4 months?
Okay. It's okay. Let's see if they have complied with the order, or you want.
No, they have not
You want to
complied.
proceed with this case, or you want to hand over the Supari?
Well, the criminal petition was filed by my colleague, the additional PP, Malad. File is with him. I am appearing for the respondent number 2 in the contempt case. The officer, he's the officer in charge of that police ASI of that police station. Well, the difficulty on his part is that number one, he is no longer there, and secondly, well, secondly, well, there is a stay order according to him. Well, therefore he has some difficulty to, because the 2 orders are admittedly there are 2 orders. Malad, the affidavit in
We can
opposition.
dispose both these cases together?
Well, the respondent number 2 has filed the affidavit in opposition in the contempt case I have seen in the month of July 2024.
Yes.
So the petitioner is aware that the order exists in the month of July 2024. He is aware that the criminal petition exists. The order exists there. Much have been said, Malad, but the petitioner is aware of the order dated 28/4/2023 stay order in the month of July 2024, because the affidavit was filed by the respondent number 2 in the month of July 2024. Even then, Malad, he is Malad pursuing the contempt case. Ultimately, Malad, my respectful submission is contempt doesn't lie because there is no willful and deliberate violation of the order. One order, Malad, says that you instead of indemnity bond, you
Yes.
instead of bank guarantee, you give indemnity bond. And the other order says the stay, order is stayed. So ultimately, the officer could not comply with the order. That is not a willful and deliberate violation of the order. So the contempt, Malad, in my respectful submission, doesn't lie. So far the pending criminal case is concerned, Malad, criminal petition is concerned, Malad. Lordship may kindly give some time, Malad. My colleague, he will appear because on merit, Malad, he will submit. Lordship can dispose of that matter in his presence.
What these matters we can dispose it of.
Contempt is as such doesn't lie because admittedly there is an order and the petition is still pending. And the other thing, Malad, on merit, the Lordship may keep it.
Yes,
there
after some time.
after some time.
My lord, absolute.
After 2, I have a DB.
My lord,
Lordship is DB or day after tomorrow.
Yeah, tomorrow maybe.
my lord will fix it day after tomorrow. I do not
Yes,
have any, but
yes.
my lord, I will satisfy your lordship that it is squarely a case of not only contempt, my lord, they have willfully set over the order of this court. I will demonstrate and I will show. After 1 year, you take an order you take an order, you take steps after 2 years, and then you come and wash your hands saying that is there. Why did they not take steps? Now just turn the table around. Had it been a private individual taking a stay order without taking any steps, will this court continue the stay order of that private individual? Definitely not. The individual will be only because they are state, they are taking these advantages. They have taken this court for a right. I will demonstrate.
These are not proper submissions.
These are
not
my lord,
correct.
these are actual submissions, my lord. Your lordship will see on what force on earth have stopped them from taking steps and why they took steps on 8th of August 2025 then. If I knew it in 2024 by means of an additional affidavit, what was the need to take steps on 8th of August? Because now both the petition are tagged, they are caught. I'm not saying the contempt petition, but on the criminal petition, which he is not representing, the criminal petition, they are caught now. So on that day, immediately, the court passed an order at somewhere around 11:30, 12, by 3 o'clock steps were taken. I'll demonstrate all this. Your lordship will fix it on the day after tomorrow. I'll show from the record.
I have seen, Malad, the Honorable Court disposed of my learned friend's petition on 27/6/2023 in the month of June 2023. And the stay order Lordship has passed on 28/4 April 2023. So stay order is prior to the order passed by my learned friend.
That is precisely what I'm submitting. Do I know it?
And the affidavit in opposition in the contempt case was filed in the month of July 2024. He knew in the month of July 2024, he is aware of.
So he said 2 years, 4 months, you are saying less than 1 year. That is the difference.
No,
He knows.
What
He knows.
he's saying is
He has the knowledge.
in the April 2023, they got an
It's okay, I got your point.
Lordship.
Yeah, I got both your
Lordship.
points. Then, but now we'll have to hear the state.
Yes, yes.
absolutely. I don't know why they are conspicuously
Today
absent.
we won't be able to wait for the state. Some other day.
Malad,
Some other day.
day after
So
tomorrow.
none appears for the
That's true.
state in criminal petition that may be observed.
Day after
No,
tomorrow.
no, that I cannot observe.
Why
I-
none appeared for the state, my lord, in criminal
No, no, I
petition?
am-
He is for the contempt.
No, I am, my lord, in the capacity of the senior government advocate, my lord. I have prayed for some time.
My lord,
I
it
don't,
is a
I don't
contempt
say.
case, he is appearing as a
No,
private counsel here.
No, in the contempt matter, I am appearing, but at the same time, I am praying in this item number 17 that lordship
Yes, you are
was sometime.
for some time during the
Sometime.
course of the day, but I won't be able to give.
No,
time.
I am not asking any time, my lord, your lordship may feel this after 15 days also.
No, no,
What I am saying is this, my lord. Here, my learned,
Today I cannot give.
today, my lord, today, my
Some
learned,
other day I can give.
my
time.
lord, my simple, my lord, it's my incapacity, I'm not being able to communicate what I am
I
saying.
understood. You want me to absent the state.
Because he is appearing as a private counsel in the content petition.
You are not getting me now, see? They are asking for some time.
In the content
Sure,
petition,
no,
in
in
the
the-
content
no, in
petition,
item-
he's asking for some time, I have no
No, no, no,
objection.
no. In contempt petition, I am asking for closure of the contempt. Because there is no contempt according to my humble submission.
No,
In
but
item
what the
number
matters are
17,
tagged along
yes,
now.
yes, lordship has tagged the
You
matter,
put the
they have
matters
to-
So
together.
state in
Okay.
this case, today in the criminal petition, the state is absent.
No, no, my prayer is for time being.
No, both the matters are tagged together.
Yes,
No,
yes.
no.
Yes, my lord.
So-
In the criminal petition, because he'll not be arguing the criminal petition, he'll be arguing the contempt.
My lord,
In the criminal
So
petition,
I won't separate the cases now. It will be remain tagged. Where is
it
the
is
Yes,
tagged,
yes, yes.
but your lordship will pass,
different orders?
no, even in the same order that in contempt, he represent.
Hmm.
But in criminal petition, the state is absent. Am I making any false submission, my lord? Your lordship will see the council is not there.
No, 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 even on behalf of, on behalf of myself also, my lord, my juniors makes prayer for some time being. I am praying for time being, making the matter time being. Lordship has expressed that lordship has some difficulty today, let it come. day
Then,
after
my lord, he is appearing, that may be recorded, he is appearing in
Yes.
both the cases.
Yes.
In both the cases, he is appearing.
No, no.
My prayer is
Mr.
there.
M. Resources present for the, contempt petitioner.
In contempt case number such and such,
No, no. Separately. Contempt petitioner, hard, no, इनका hard लिखा था. Council Mr. M. Resource for the contempt petitioner and learned senior government advocate, Mr. D. Nath for. Here you are appearing for.
Don't go over.
contempt
For
petitioner.
respondent number 1 in contempt case. Respondent number 1.
For respond.
One.
For respondent number 1.
1.
And about 2, respondent.
To my Mr. M. Bhagavati, he appears and he has filed the affidavit. That affidavit is filed below. Mr. M. Bhagavati, he appears.
Learned counsel, Mr.
No, M. Bhagavati, he's not possibly here, madam,
Not here.
but he has filed a wakalatnama, his name is here.
It is respondent number 1 लिखित हुई है. The respondent number 2 is not represented today.
He's not there.
I mean, he is not represented today. List the matter on after 2-3 days.
yes, absolutely. My lord, maybe next Tuesday, my lord, because this week down the later part of the week, I'll be out of station. So some more.
He is telling a date, 18 November.
Let it be on 17th, madam.
17th.
On 17th,
Part to be.
Monday. 17 is Monday. Monday, good. Lordship.
Learned counsel, it will contempt petitioner Vidya, learned counsel Mr. M. Resource is present. For the respondent number.
In contempt, I'm not respondent. In this, I'm
Criminal
respondent.
petition.
Criminal petition, I'm for all the respondents.
For respondent number 1 and 2, full stop. List this matter on 8 to 10 again, date
17.
along with content case number and again.
Lordship.
I'm representing.
High level, Lord.
Item 18. Yes, please.
Lordship, as per official dated 2/11/25, AD card upon respond number 2 and AD card upon respond number 2 and 3 has not been received, Lordship.
Okay. Awaited,
Awaited, Lordship.
Learned counsel Miss. Your name?
F Intas,
F. Intas is present for the
appellant.
appellate. Learned counsel Mr.
KK Bhatt.
K.K. Bhakta is present for respondent number 1. Service report on respondent number 2 and 3. 2 and 3.
Lordship,
I'll check. Should I check the office note?
2/11/25, Lordship.
এই ডেটটো নাই দিয়া দেখোন। Okay. Issued by date, নাইনৰ 20 তাৰ আগৰ হ'ব, এইটো হ'ব চাগে। ডেট কিয় নাই দিয়া? We do not have to office note of বেলেগ কেছ আছে নেকি? তাকে একেলগে আছে নেকি? 23/9 now. Notices of advertisement have been issued. You want to take fresh steps?
AD card has not been received, Lordship.
Has not been received. Okay. So service report on response number 2 and 3 is awaited as per office note dated 23/9/2024. It was long time back. That's why I'm asking.
2/11/25, Lordship, kindly pay.
No, no 2/11/25, 12/6/25.
Sorry.
এইটো লাষ্টৰ লাইনটো কাটি দিয়াচোন। Service report number. Office note dated 12/6/2025 indicates that service report on respondent number 2 is awaited, whereas notices have been served to the respondent number 3. This is the matter after how many? 2, 3, 4 weeks?
2 weeks.
This is the matter after 2 weeks. Item 19.
Okay. In this case, I am paying 3 week time for filing APTP Lordship.
Okay, yes,
Regarding
3 weeks
process.
time.
My lord, I am for respondent number 1. Delay condonation petition is there, I think.
Mr. KK Bhatto has submitted for 3 weeks time to file
My
affidavit.
lord, delay condonation, I have no objection, my lord, to buy. Only 22 days delay.
Delay may be condonation.
Delay may be condoned.
All right. Learned counsel, Mr. KK Bhatto is present for the applicant stroke appellant and learned counsel, Mr.
Admission of one listed over here.
Yes, Sharma
Yes, sir.
is present for respondent number 1 and 2.
One, my lord.
But here, J. Sharma, respondent number 18 or 19?
19, my lord.
Okay. Here your name is shown as respondent number 1 and 2,
1 and 2.
and Mrs. M. Borua also shown as respondent number 1 and 2. Data cause list. This application is filed under Section 5 of the Limitation Act for condonation of delay of 22 days in filing the connected appeal. It is submitted on behalf of the applicant that the delay was a result as the file had to be sent to the head office for vetting. Okay? It appears that there was no malafide on the part of the applicant, stroke applicant, whose substantial sufficient reasons have been shown for the delay in filing the connected appeal. Full stop. No inaction on the part of the applicant is discernible. Thereby, delay of 22 days is condoned. Ready to register the connected appeal.
My lord, for admission. Obliged.
Service upon the respondent is not started, not completed.
The respondent number?
Sole respondent.
Sole respondent. Learned counsel, Miss
P. Mishra.
P. Mishra is present for the petitioner. Full stop. Service report on respondent is awaited with the matter after 2 weeks.
Fresh steps. Fresh steps.
Petitioner may take fresh steps to issue notice to the respondent.
There is a delay of 38 days, but respondent number 1 is the claimant. Appear, but 2 and 3, my lord, office note dated 6/11/25.
2 and 3?
2 and 3 owner and driver.
Okay.
Basically, we have no allegation against the owner and driver. We have challenged.
Do you have any objection? 30 days only.
Lordship, actually, my senior is running late.
Senior?
Senior is running late. He's
Okay.
on the way.
Okay, okay, okay.
38 days, my lord. Can you come down?
I will come down, but
Let
it's-
wait
let us
for
see
some
your
time.
submit.
Detail, month and like. I see. No, just one.
Lordship, I'll put the owner, Lordship,
Yeah.
I have no objection, Lordship.
Owner, claimant.
Owner. No,
Claimant.
Claimant.
claimant, claimant, okay.
38
You have
days,
no
my lord.
objection.
No,
All right. If
38
the
days.
claimant has no objection, then no problem. You are for the insurer.
Yes,
Learned counsel, Mr.
RC Pal.
RC Pal is present for the insurer.
Appellate.
For the applicant, and learned counsel, Mr.
MS.
MS Alam
Yes.
is present for the claimant.
Yes.
Kumar,
Number
number one.
Yes.
Full stop. This application is filed under section 5 of the Limitation Act 1963, read with section 173, 1, within bracket 1, proviso of the MPA, with prayer for condemnation of delay of 38 days in filing the connected appeal. It is submitted that the delay was the result of forwarding the decision to the head office,
Right?
to the head office
Had a regional office.
or to the regional office
Guwahati.
for vetting. Full stop. The learned counsel for the claimant has no objection. Full stop. Sufficient grounds had been demonstrated by the applicant. Full stop. Delay is hereby condoned. Registered to register the connected appeal.
Well, after registration of the claim, in the appeal, his name may be shown, otherwise.
And to reflect the name of M. Alon,
MS.
As asked.
MS Alon in the cause list as, it is already there. 21,
Well,
it is already there.
no, in the main appeal, when registered, then his name may
Or
be
in
shown
the
otherwise.
cause list.
Yes,
the-
I'll have the copy.
All right, in the cause list of the appeal, registered appeal.
Much. Also.
Item 22 for the. Oh, yeah, no.
But please, your lordship. Your lordship, Mr. Kyal is on legs on court number 10, your lordship. Kindly take it over after some time, your lordship.
This is the last case. Last case, and you see, afternoon I cannot take it up.
Yes, your lordship.
Whenever he is here, then you call me.
Yes,
I'll
your
come.
lordship.
Afternoon, I'll be sitting for division bench, so,
Your lordship will be free in some time. Your lordship.
all right. Marty,
We file an application page 36, annexure 3.
Yeah.
Raising some preliminary issue that was framed and decided against the petitioner. But suppose appreciate the entire issue, I am to place annexure 3, page 36.
page 32 or 36?
36.
Page 32 was the order.
Page 40 is the order.
Page 40 is the order, okay.
Page 36 is application filed by the petitioner. Married list.
Yes, page 36.
Page 36, annexure 3.
Yes.
Petition under section 151 CPC of the defendant number 1, 5 and 6. Paragraph 1, that the plaintiff has instituted the suit against 7 numbers of defendant who are the legal heirs of original tenant late Banwarila Lagawal for their eviction from the suit premises and also for area rent and compensation. All the legal heirs of representative of the deceased tenants are necessary party in the suit for eviction, and in absence of all the legal heirs representative of the deceased tenant, the suit is not maintainable, and the plaintiff knowing well the facts had made all the legal heirs of the original defendant, original deceased tenant, Banwarila Agarwal is defendant number 1 to 7 in the present case. During the course of trial, summons were served on defendant number 1, 5 and 6 and they appeared and are contesting the suit by filing their written statement. Next, paragraph 4, that no summon were served on defendant number 2, 3 and 4 and the plaintiff also failed to take steps for service of summon on defendant number 2, 3, 4 in spite of repeated order by the learned court and thus the defendant learned court by order dated 29/5/2018 dismissed the present case for default against the defendant number 2, 3 and 4. That the defendant number 2, 3 and 4 are proper and essential and necessary party and they derive the joint and heritable right in the eviction suit along with the other legal heirs of original deceased tenant Banwarila Agarwal. Then the plaintiff has realized the aforesaid facts on dismissal of the suit against the defendant number 2, 3 and 4 and to cover up the aforesaid mistake, the plaintiff filed miscase being number 3 of 2019 of this court, learned court for restoration of the case against the defendant number 2, 3 and 4. That in miscase Miss J case number 3 of 2019, the plaintiff was not diligent and did not took steps for service of the summon of the miscase on defendant number 2, 3 and 4 and ultimately the plaintiff filed a petition on 23/2021 to withdraw the miscase being number 3 of 2019 and this learned court was pleased and dispose of miscase number so and so and withdrawal on 23/2021. That presently only the defendant number 1, 5 and 6 are party in the present suit. And the case against the defendant number 2, 3 and 4 is dismissed long back as mentioned herein above. All the legal heirs of the representative of the deceased tenant had acquired heritable right in their tenancy and all are necessary party in the suit. In absence of all the legal heirs and legal representative of the deceased tenant as party in the suit is not maintainable. That in the present suit, although all the legal heirs of the original deceased tenants were made party, but subsequently the case against the defendant number 2, 3 and 4 was dismissed on 29/2018 by this court and as such the suit of the present defendant number 1, 5 and 6 ought to be dismissed being not maintainable due to absence of all necessary and essential party. So accordingly, Lordship petition filed this application and preliminary was decided, Lordship, page 41. This is the order dated 29/10/2022. May I read, Lordship? Page 41. Today is the fix for rendering decision on preliminary issue framed on the point of law relating to question as to whether, in absence of all legal heirs of the deceased tenant, let's say Banwarila Agarwal, Section 2F of the Assam Urban Area Rent Control Act bars the maintainability of the suit for eviction under the Act. In the instant case, the plaintiff has instituted the suit as landlord for a degree of possession of the suit premises projected the plaint by way of eviction of the defendant tenants that from on the ground of default in payment of rent and bona fide requirement and further for recovery of area rent. The suit premises is a business cum residential premises situated in Jaipur Moja of Dibrugarh district with holding number 8 of Naharkatia Town Committee. Clearly, the suit premises situated within the limit of the urban area of Assam and as such the suit of the plaintiff is under Assam Urban Area Rent Control Act 1972, herein referred to as the Rent Act, and the relief of recovery of possession is therefrom sought under Section 5 of the Rent Act. The issue at hand come to be framed upon contention in writing made by the defendant Srimati Kamala Devi Agarwal, Sri Ankit Agarwal and Srimati Munni Agarwal, who are respectively the widow, son and daughter of Sri Banwarila Agarwal, to the effect that since all the legal heirs of the original tenant of the suit premises, that is suit that the said Sri Banwarila Agarwal are not the parties to the suit, Section 2F of the Rent Act bars the maintainability of the suit and as such it is prayed for dismissal of the suit. Both the sides are well duly heard through their learned counsel. It apparent that the plaintiff, that the originally, while instituting the suit, the plaintiff had implemented three more daughters of late Banwarilal Agarwal, namely Srimati Sangeeta Agarwal, Srimati Neelam Agarwal, and Srimati Parmila Agarwal as defendant number 2, 3, and 4. However, by order dated 29/5/2018, the suit was dismissed as against the said defendant under Order 9 Rule 2 CPC on failure of the plaintiff to take necessary steps for serving summon upon the said defendant. The plaintiff, though applied to set aside the dismissal set aside by number so and so, but eventually withdraw the case on 23/2021. Result, the dismissal order was not set aside, and thus attained finality. Further, on 23/2021 itself, the plaintiff also got the name of the defendant number 2, 3, 4 and another defendant number 7, namely Srimati Shamla Agarwal, stricken off of the plaintiff on the ground that they were improperly made parties to the suit. So the present position is that the defendant are not more the parties in the suit. At the time of hearing of the learned counsel for the defendant strongly relied on section 2F of the Rent Act, which defines the meaning of tenant, to submit that having inherited the tenancy right upon death of late Banwarilal Agarwal, the aforesaid three daughters also come within the meaning of tenant along with the defendant, and thus they are necessary party to the suit, which for eviction of the tenant from the suit premises. Learned counsel for the thus argued that by raising a point of law that unless all surviving legal heirs of late Banwarilal Agarwal are parties to the suit of eviction under the Rent Act is not maintainable in view of section 2F of the Rent Act, and the present suit is therefore liable to be dismissed. Learned counsel relied on the following cases in support of his argument. Next, on the other hand, while the learned counsel for the plaintiff admitted the tenancy right of the aforesaid three daughters of the late Banwarilal Agarwal, he also contended that since all the legal heirs of the deceased tenant are not occupying the suit premises, only those in occupation are necessary party. He relied in case of Grover Singh Sonso in support of his contention. To consider the argument made on behalf of the defendant, let me reproduce section 2F of the Rent Act solely on which there are strongly relying in order to question the maintainability of the suit, and which is as under. F. Tenant means any person whom or on whose behalf rent is payable for any house, and includes every person who from time to time derive the title under the tenant. It is obvious that section 2F defines the meaning of tenant, or other words, emphasis as to who shall be treated as tenant for the or intends to propose of the rent rate. While referring to the definition of tenant, also counsel for the defendant also emphasis on the word and includes every persons whom from the time to time derive the title and the tenant, to submit that on the death of the original tenant Banwarilal Agarwal, his aforesaid three daughters who were not the parties to the suit also derived the title over the suit premises along with the defendant, and as such no effective decree of eviction can be passed in absence of the said three daughters. Learned counsel thus argued that in a suit for eviction by the landlord implemented all the legal heirs of the deceased tenant is therefore necessary, and if not so done, the suit barred under the law in view of section 2F of the Rent Act. So it can be seen that the title inherited by the legal heirs is defendant have referred to, and thus relied upon section 2F of the Rent Act to question the maintainability of the suit in law. Honorable Supreme Court in case of Suresh Kumar Kohli versus Rajesh Jain reported in so and so has considered the question as to what would be the status of succeeding legal representative after the date of statutory tenant. It may also be mentioned here that the Rent Act does not make any distinction between contractual tenancy and statutory tenancy in terms of right, obligations and incidents provided under the Act. The facts in the aforesaid case were follows. The owner of the shop had let out the premises on a monthly rent to the defendant and his father. The owner sent a legal notice to the defendant and his father terminating the tenancy. Thereafter, the father of the defendant dies. Since the defendant failed to vacate the suit premises, the owner filed the eviction suit under the Delhi Rent Control Act. On the ground of bona fide need, the eviction petition was decreed in favor of the owner. Finally, during execution proceeding, brother of the defendant filed the objection before the rent controller, claiming that he is the necessary party as he is inherited right in a joint family business and he was not aware of the pendency of the eviction proceeding. The rent controller rejected the objection. On challenging the said order, rejection before the High Court was reversed. On being aggrieved thereby, the owner thus preferred appeal by special petition leave before the Honorable Supreme Court. In the above following observation made in case of S.C. Pandey versus so-and-so was emphasis that the Honorable Supreme Court which as follows. 4. It is well settled that on the death of original tenant, subject to any provision to the contrary, either negative or limiting the succession, the tenancy right derives on the heirs of the deceased tenant. The incident of tenancy are the same as those enjoyed by the original tenant. It is a single tenancy which devolves on the heirs. There is no deviation of the premises or the tenant payable, rent payable thereof. The debt is the position as between the landlord and the heirs of the deceased. In other words, the heirs succeed to the tenancy at joint tenant. Finally, the Honorable Supreme Court conclusion. We are of the view that the light of the S.C. Pandey, the situation is very clear that when original tenant dies, the legal heirs inherit the tenancy as the joint tenant and occupation of one of the tenant is occupation of all the joint tenant. It is not necessary for landlord to implement all the legal heirs of the deceased tenancy, whether they are occupying the property or not. It is sufficient for the landlord to implement either those persons who are occupying the property as party. There may be case where landlord is not aware of all the legal heirs of the deceased tenant and implementing only those heirs who are in occupation of the property is sufficient for the purpose of filing the eviction petition. Eviction petition against one of the joint tenant is sufficient against all the joint tenant, and all joint tenants are bound by the order of the rent controller. As the joint tenancy is one tenancy and is not tenancy split into different legal heirs. Thus, the plea of tenants on the count must pay. So, in the light of the above laid down by the Honorable Supreme Court, it can be said that the title which legal heirs of the deceased tenant inherited is one of the nature of joint tenancy, and therefore the landlord need not necessarily implement all the legal heirs in a proceeding of the eviction, whether they are occupying the property or not. All the joints tenant are bound by the order of the rent controller. It is therefore follows that the legal heirs of deceased tenants are not necessary parties to a suit for eviction by a landlord. Insofar as provision of 2F of the Rent Act is concerned, it is OPS do not speak specifically with regard to the bar to a suit or occupying the joint of the party. In fact, there is no provision under the Rent Act speaking specifically on the point to bar a suit which refers to non-implementing of the parties. In case of Sushant Kumar Kar versus so, this AR 2015 Guwahati are relied upon by the Learned Council for the defendant. There was no issue before the Honorable Court with regard to pure question of law relating to bar of the suit under Section 2F of the Rent Act. In fact, the observation were made on the basis of eviction led before the trial court. The Honorable High Court, from the evidence of PW1, gave the observation that although the presence of the other legal heirs of the original tenant was known to the landlord, he refused to acknowledge the others and only recognize the defendant as the sole tenant for the suit premises and process. The protection of the right of the other legal heirs from being unlawfully ejected was threatened, and therefore on this ground it was observed that when the tenancy rights are inherited jointly by the legal heirs and specifically for non-joinder of parties is taken in WS, the plaintiff ought to have taken steps to implement the consent successor, and thus it was held that the suit was not maintainable for absence of legal heirs of original tenant. It is clear on the perusal of the judgment. In fact, the circumstances of the case is with regard to the clarification of tenant, which has been held by the Honorable High Court with reference to section 2F of the Rent Act, to hold that the legal heirs of the deceased tenant will be covered under the definition of tenant, and thus it was noted that the legal heirs of the original tenant were not implicated despite the specific objection, and so defendant was fatal for an ejectment. In case of Ranjit Kumar Chaudhary versus so and so, 1996, one Guwahati Law Journal. It was, so there was no observation given in regard to the bar to section 2F of the act. The relevant portion of the judgment is restricted below. Nothing has been disclosed in evidence that said other heirs of and legal representative of the deceased are not staying at the said premises, and or that the said persons had at any time surrendered the tenancy in favor of the defendant solely with landlord. They had acquired heritable right in the said tenancy, and the same continued to subsist between the landlord and the heirs of the legal representative of the deceased tenant. In this contents, I refer to clause F of section 2 of Assam Urban Rent Control Act, which reads as follows. Tenants means any persons whom or on whose behalf rent is payable or in any house, and includes every persons from time to time derived the title under the tenant. That the definition of tenant shows that so that not only the original tenant but also the other persons derive the title under a derivative title is also tenant. As such, the suit in the absence of all the legals and legal representatives of the deceased tenant are not maintainable. There was some rightly dismissed by the trial court, inasmuch all the legal heirs of representative of the deceased tenant were necessary party, an essential party in the suit, but they were not implicated as parties. The landlord, as plaintiff realized that the importance of the same, and obtain an order from the trial court to make the suit from said persons as party. However, after obtaining the order of getting them as party, failed to do so.
All right, I have read it.
Lordship here, Supreme Court says that, and he has only one representative is made party, then suit is maintained. Here, Lordship may please to see the plaintiff. He has implicated all the respondent, including the, let's say,
But it was dismissed, no?
No, Lordship, what happened, Lordship may please to see. Page 12. Initially, he implicated all the legal heirs as a party respondent. He failed to take state, that suit was, that application was dismissed. Again, he filed for application for restoration. Again, we realized then he filed application for deleting their name. And he subsequent for deleting their name from the place. That was allowed. But seeming to see first, let's say he knows that it is not the case of the plaintiff, that is not, does know about the legal name of the legal heirs. Because let's say the plaintiff reveals that he knows about all the legal heirs, initially implicated. So under the circumstance, let's say the trial court has misled himself, and the judgment side by our High Court, that is lots of more relevant. It's not placing two judgments, that is another court. That's why we written the paragraphs in the front of the front page. There are two judgments. One is of 1993. 1993 supplement GLR 113. Party name is Suranjan Dev versus Mohtarma Hamida Khatun. Then another is Ranjit Kumar Chaudhary on the death of Amal Chakravarti, his legal heirs. So here, Lordship, 1995, Lordship, paragraph 6.
Paragraph?
Paragraph 6 in 1995. I've given the paragraph in the top of the judgment.
Paragraph 6.
Paragraph 6 of 1995.
Yes, yes.
I have carefully considered the submission of the counsel for the parties and held that the heirs and legal representative of the deceased tenant had stepped into the position of contractual tenant of the said premises on the death of their father. Admittedly, the original tenant left behind him his widow, 2 sons and 2 daughters. Nothing has been disclosed in the evidence that the said heirs and legal representative of the deceased are not staying in the said premises, and the said persons had at any time surrendered the tenancy in favor of the defendant, so solely with landlord. They had acquired heritable right in the said tenancy, and the same continued to subsist between the landlord and the heirs and legal representative of the deceased. In this context, I refer to clause F of section 2 of Assam Urban Rent Control Act 1972 is read as follows. Then the definition of tenant shows that only the original tenant, but also other persons who derives a title under the derivative title also tenant. As such, the suit in absence of all the legal heirs and legal representative of the deceased as tenant are not maintainable. But the same was rightly dismissed by the trial court in as much as all the legal and representative of the deceased tenant were necessary and essential parties in the suit, but they were not implicated as party. The landlord, as the plaintiff, realized that the importance of the said same and obtained an order from the trial court make the said persons as parties. However, after obtaining the order for adding them as a party failed to do so. This is very fatal omission on the part of the landlord. But if here the suit is initially stays, trial is not yet commenced. Only we file application, circumstances will explain that.
So it's in the initial stage.
Yes, Lord.
Cross-examination of PW1.
Nothing,
I
Lordship.
think.
Nothing has been done, Lordship. Only we file application, Lordship, because they took initially they implicated all the legal representative. Since they failed to take steps on respondent number 2, 3, and 4, defendant number 2 and 3, 4, their suit was dismissed. That petition was dismissed. Thereafter, they file application for revival of their name. That was also withdrawn by them. Subsequently, they file application for deleting their name because they are not necessary part. So, Lordship, and the stage Lordship is not come, even issue has not been framed, Lordship. And Lordship, the judgment relied by the Supreme Court is not applicable in the present case. Here, Lordship, in other cases, the parties were, the legal heirs were not not implicated as a respondent, dependent Lordship. Then when the suit was decreed, then one defend legal heirs, he approached the rent controller. Then so initially that was application was dismissed. Then High Court reversed, then matter went to Supreme Court. Supreme Court said no, only one representative will do. But here, Lordship, he has know that all the he was not aware that all there are other legal representative or legal heirs are there.
Okay.
District Magistrate may consider all these judgments.
My lord, short reply, my lord. First of all, the application which was filed by the defendant, that is not maintainable per se. If my lord may kindly peruse page 36, this is an application under section 151 of CPC.
Okay.
First of all, that my lord. Secondly, my lord, in the written statement, no plea of non-gender of necessary parties was taken. My lord.
Yes, you have submitted.
Yes,
that.
my lord, because if my lord may kindly peruse the written statement so filed, there is no specific prayer that this suit is bad for non-gender of necessary parties. Thirdly, my lord, the judgment which I relied upon, the 2023, this judgment has been now reported as 2023 13 SCC, page 1. This judgment, my lord, and the other judgment of 2018, which was cited by the learned trial court, has made it clear, my lord, that even if there has to be substantial representation, if the defendants are there, it would not mean that the suit is bad for non-gender of all the parties, my lord. So that is my case, my lord.
Yes.
So I pray for dismissal of this revision petition, my lord.
Lordship, on factual ground, my learned friend says that it non-gender party. This is not the case, Lordship. They were implicated as a defendant in the main suit. Lordship. They failed to, the plaintiff failed to take steps on this defendant, so suit was dismissed against the particular that dismissed. Again, they file application for revival. Again, Lordship, third time they file application for deleting the.
Now, what is your prayer?
Lordship,
your
my
prayer?
prayer is that the suit is not maintainable in absence of all the legal representative. And the judgment cited by my learned friend and relied by the trial court are not applicable in this case.
So that you want that
suit is-
you are against the order where the parties were not, your prayer was there to impede the parties.
Lordship, since they were not party, subsequently their names were deleted, was deleted by the learned trial on the prayer of the plaintiff. Because he knows about everything, all the legal errors. Initially, he pleaded all the respondents, all the defendants. It is not the case that he was not aware. That is the case of case, it will be different. He could have only pleaded one respondent, defendant, in place of diseased tenant lot. Under the circumstance, Lordship,
Your prayer, let me see, check your prayer.
my prayer, Lordship, page 38.
Page?
Page 38.
No, here in this,
Here, Lordship, to set aside the order.
to set aside the order,
Lordship. Page 19.
page 19,
Lordship.
to set aside the,
Lordship, order dated 29/10/2022.
okay. This preliminary issue was framed based on what?
Lordship, on our application, this application,
Where is the application?
Lordship, page. Page 36, Lordship.
Or this was the application? Okay, all right.
Lordship. Much.
Anything else?
No. I have already given the judgments that, okay.
Yes.
There's also judgment of the Guwahati High Court. Relevant paragraph is paragraph 30, my lord. Subsequent
High
suit is not barred, my lord.
Sorry?
Subsequent suit is not barred. Paragraph 30. 2023 5 GLR NOC 23, my lord. Hasna Rahman versus Ahmed Tea Company.
Last
I
time
want,
you-
no, I can give one more copy.
Here question of subsequent suit does not arise because it has not been filed by them.
Sorry?
Subsequent suit
Ah.
has been relied by net friend. This speaks about there is no bar in filing subsequent suit. But should I also note, this is a clear person, but he has not filed any subsequent suit also. Let him withdraw the suit and file again, Lordship, what is the problem? If he is relying on that.
Well, I am covered by my Supreme Court judgments because I am covered by those judgments. And the learned trial court has rightly applied the principle, my lord. My lord, may kindly peruse the learned Supreme Court judgment, my lord, the Honorable Supreme Court judgment. I am covered by those judgments.
At Learned Counsel, Mr. SCPI for the petitioner and Learned Counsel, Mr. S. Khan for the respondent.